So yes, again, good afternoon. We'll begin this session with a brief background of the day's topic, after which I'll introduce our panelists. So please note that this is a fully virtual session, which is being recorded. And if you have any questions for the panelists, please feel free to type them in the chat box at any time during the session. And towards the end, we'll have a dedicated question and answer segment, and you're welcome to but regardless, you're welcome to post your questions as the discussion unfolds. For those in attendance, I'd also like to flag that if you have any questions specifically for Mr. Kegoro, please feel free to raise them as the session unfolds because he won't be with us for the full duration of this webinar. But yeah, any questions posted later shall still be forwarded to him, and hopefully we'll be able to get feedback. So today our focus is on an emerging but critical area, that is fourth generation rights, evolving rights in the digital age. The promulgation of the Constitution of Kenya 2010 marked a watershed moment in Kenya's legal and political history. The Constitution, however, not only established a strong foundation for civil, political, and social rights, but also allowed room for the recognition of evolving rights. And this is captured, I believe, in Articles 19 and 20 of the Constitution. So these rights include the right to privacy, data protection, online identity, and access to information, which really shall form a huge part of today's discussion. So this fourth and final webinar in the Katiba 15 series seeks to interrogate how the Constitution accommodates and responds to these emerging frontiers, with a special focus on court jurisprudence, legislative reforms such as the Data Protection Act of 2019, and current debates around digital governance. This session offers forward-looking reflection, the interaction between technology and human rights in Kenya. With us today is Mr. George Kegoro and Mr. Dennis Nkarichia. Mr. George Kegoro is the current executive director of the Open Society Initiative for Eastern Africa, which is part of the Open Society Foundation, which works to champion the search for bold democratic solutions to some of the urgent common challenges that advance human rights, equity, and justice. Mr. Dennis Nkarichia, on the other hand, is an associate within the Dispute Resolution Practice Group at Mohammed Mugai LLP, and is also a lecturer at Kabarak Law School. His practice focuses on constitutional law, employment and labor relations law, and elections technology. To our panelists, thank you so much for honoring this invitation. And to everyone who has joined us today, asanteni sana, and we hope to have a very productive and interactive session. So I'd like us to begin this conversation with a quick glance at the situation that was there prior to the promulgation of the Constitution 2010. And I think this should be particularly important, or rather a good starting point, because it would then help us appreciate how different the post-2010 era is. And I'll pose this question to both our panelists, starting with Mr. Kegoro. Mr. Kegoro, if you could kindly unmute so that you're able to
All right.
get you.
I would say thank you very much, and thank you for the opportunity to share learning in this conversation. I would say this, that the Constitution of Kenya that was in place before the current Constitution in 2010 did not contain any of the rights that we are now talking about here. So I think let's just go back to the evolution of rights. So you've had the first generation of rights, which are basically political rights. The second generation rights, which are socioeconomic rights. The third generation rights, which are associational rights, rights of groups. And now we've got these the fourth, so-called fourth generation rights, which are rights around that deal with the emergence of technology, digital technologies, but also the challenges emanating from the environment and and in particular the climate challenge. So none of these rights were contained in the earlier versions of the constitutions of Kenya. And we come to these rights, particularly, let me speak about the access to information. I was at the Kenyan section of the International Commission of Jurists when we were advocating for the access to information as a right. We were advocating for it as a statutory right that would be just an access to information legislation passed by Parliament. President Kibaki had already pronounced himself positively about the possibility of such legislation. And we never, in our wildest of imaginations, thought that there would, in addition to making these a statutory right, that an opportunity would arise to elevate this to the constitution itself. So, in the nature of how the country evolved and the Constitution of Kenya moment coming as a result of the violence of 2007 and then forcing the country to write a new constitution, the opportunity then arose where not only did we secure these as a right under statute as has come to pass, but it also became a right under the Constitution, which is something that was not in our original imagination at that time. So the short answer is we've wildly moved, I think, in the sense of that advocacy that I was involved in. We overachieved in terms of the ambitions that we had because we came from no rights to rights being guaranteed under the Constitution. Thank you very much.
I'd like to pose the same to Nkarichia to just give us an overview and your take on the same.
Thank you, Jesse. I think from where I sit, the most fundamental distinction and being that you'll note is if you look at the 1963 Constitution, from Article, I think, 70 to Article 83, it starts with the word protection from. If you look at the current Constitution, the rights begin with the word the right to. That shows at a conceptual level, as a country, we have jurisprudentially moved from the position that all rights were granted to you by the state. At the instance of the state, and state had the obligation to decide when do you get to enjoy your right, how do you get to enjoy your right, and to what extent is there a reasonable limitation? Why? Because if I tell you there is protection from the university, it means, number one, there is a threat. And then there's an obligation for someone to protect you from that threat. But it also means that person who is protecting you is giving you that right at their own discretion. They can wake up tomorrow and decide, I no longer want to protect you. They can wake up tomorrow and say, my protection for you is limited to this extent. So when we have this conversation of first generation, second generation, and third generation rights, it's usually a conversation that begins with the question, what is a human right? If it's an inherent requirement for the sustenance of life, then it becomes something that you are entitled to, not because the state gives it to you, but because you are very foundational nature as a human being. Now, if you take another step back, as Mr. Kegoro has mentioned, the distinctions between second, third, and fourth generation rights are predominantly artificial, if I could say so, because when you hear people saying the political rights, this is a conversation that began between 1945, after the Second World War. And when the League of Nations collapsed, it became critical for the European powers to try and advance a society where people could interact freely. And that free interaction of people led now to the recognition of political rights as fundamental to you people. Because remember, before 1911, the First World War, the entire European civilization had been based on a question of aristocracy and the question of to what extent can you become better than your betters or your equals, as they will say. So that the first generation, the core right to life, right to shelter, these were deemed rights that everybody was entitled to, whether you are a peasant, whether you are a lord, or whether you are a lady, whichever circumstance or your social circumstances were. But the second generation only pick up when during the interwar period and the post-war period, it becomes recognized that for you to have a coexisting society, you need to protect the bare means through which people express themselves. But even in that expressing themselves, you will find that not all these countries that are advanced their position that everybody was entitled to that right, that freedom, adopted it. Ask yourself, when did women get the right to vote? When did Black people or people of color get the right to go into integrated schools in the United States? So it's a progressive realization that once people are able to speak, you then also need to secure the economic means. And these economic means is what you have socioeconomic rights. And once you get the socioeconomic rights, the fourth generation now becomes as a response to recognizing that when we were perceiving socio-economic and political matrices upon which the society is founded upon, we perceive them through the prism of the technology available to us. Now that technology has fundamentally changed, the question that arises, are there inherent qualities or inherent circumstances that are necessary for someone to be able to achieve their highest social and I would say economic development? Then the question comes of, do we need fourth generation rights? So that the fourth generation rights are viewed as what we could call autochthonous. Given the circumstances in which we find ourselves, what rights do we need to promote and safeguard to ensure everybody can realize their highest standard? That's my take, Jesse.
Yeah, thank you for that, Mr. Kegoro. Thank you, Mr. Nkarichia. Just to pick off where Mr. Nkarichia has left off on this generation being more or less autochthonous, I guess we could then delve into more or less appreciating what exactly Articles 19 and 20 have provided, or rather the kind of room that they have created for us, because this would then lead would serve as a segue into looking at some of the legislative reforms that have been there. So probably quickly to you, Mr. Kegoro, the value that has come with Articles 19 and 20, how has this then created that room to recognize these emergent rights, or rather the room for emerging rights?
Sorry, can you repeat the question?
So, okay, my question is, as Mr. Nkaricha has put it, the fourth generation of rights are in a sense autochthonous. And so, with this in mind, how then have Articles 19 and 20 come to reflect this, or rather come to create room for the recognition of emerging rights? Because this would then lead as a segue, or rather would serve as a segue into how it's playing out within the legislative space, within the judicial space.
So the thing, and I like the discourse that Mr. Nkarichia started. It is a discourse uh, that is important because in the old constitution, the whole constitution not only has that approach of that is talked about protection from, but it also has inherent in every right that was in the Bill of Rights, there would be a qualification of that right. There would be a clawback clause. For example, you have the right to life, but that right is taken away by the recognition of the fact that you could suffer a penalty imposed by law. That basically means that the death penalty, for example, that is the way in which the right to life coexists with the death penalty. The freedom of expression then has qualifications that under the old constitution allowed clawbacks that made it possible for sedition and sedition types of laws to also be justified to coexist with the constitution. So what we have under the new constitution is a departure from that old experience where, first of all, there's a recognition that these rights are not granted by the state. They are rights that you arrive as a human being possessing, and they're not gifts or a gift from the state. That's the first and important thing. The second thing is that the clawbacks uh, are removed, and there's an omnibus explanation at the head of the rights. There's an omnibus explanation about how the rights should be interpreted, and the interpretation of those rights being in favor of a right as opposed to being in favor of the clawback, which was experienced in the old constitution. The third innovation is the procedure for claiming those rights, the procedure for accessing redress where there's a claim that a right has not been honored. The old constitution again had um, provisions to the effect of who could approach a forum of redress, typically a court of law, and that was the rule about locus standi. That has been addressed very differently in the new constitution, down to the point where the new constitution says that the lack of rules of procedure for accessing courts will not stand in the way of accessing those rights. This is a response to the old constitution, which had a similar provision where the Chief Justice was required to make rules, had not made rules for years, and the court would say that the lack of rules of procedure for accessing the Bill of Rights, the access to remedy under the Bill of Rights, was itself a bar to access to going to courts. Whichever method you use to go to court, whether you used a plaint, an originating motion, or a petition, or whichever other form of legal documentation you filed, courts found that you were not properly before court because you had not formatted your claim in a manner that was legally recognizable, and the court were themselves unable to tell you how to approach them because the rules of court under which you could approach them have not been made by the head of that same judiciary. So I think those are three mechanisms that are a great departure from the old constitution, and that go well into the not just the substance of the rights themselves, but the culture that the constitution wanted to put in place around the discourse on rights.
Yeah, thank you for that. And now probably to Mr. Nkarichia, with sort of this foundational basis that we've laid out, one of the highlights in terms of progressiveness in acknowledging rights, for instance, we have the Data Protection Act of 2019 in the legislative font for the judicial space, or is the same being progressively realized within the judicial space? And with that in mind, are there shortcomings that still need to be addressed? And are there as well like significant wins that you also need to acknowledge on the part of the judiciary, for instance?
Thanks, Jesse. You have asked a question, but 200 questions in one. So I'll try and take the bits that I think I got. The first bit that we have to recognize is what Mr. Kegoro says. But they initially sought for something and they got a better offer than they ever expected to get. And the most famous case that everybody who has practiced law will meet is the case of Anarita Kareminjeru, a poor teacher who decided to vie for an electoral position in the heartlands of Meru County and met patriarchy, or so they claim, along the way. And when she tried to access court, the question of locus standi became the foundational case that we used to rely on until post-2010. Now, if you understand that the entire 2010 Constitution was a response to the circumstances we found ourselves between 1963 to 2010, then it becomes very easy for you to appreciate the simplest thing that the Constitution has done today is what to call Article 19 very B. But the rights and fundamental freedoms in the Bill of Rights do not exclude other rights and fundamental freedom of rights. What that does is materially, under the old constitution, if a right was not provided for in constitution, that right did not exist. That will become a privilege to you to be afforded by either parliament or the president at his discretion. And which is why the old constitution granted the president the powers under the Preservation of Security Act to invoke or withdraw rights whenever he felt fit for 28 days, depending on whatever circumstances. And the only limit on presidential power was that 28-day limit. So you find that the current constitution recognizes, even if a right is not provided here, since we say these rights are endowed to you by your nature as a human being, those rights can be also to be enjoyed. So that if you come to the data protection, you'll find that the Data Protection Act is a recognition, but the entire 21st century has been running on the invention of the wheel and the discovery of oil. So that if and each and every human advancement over the last, I would say, 60 years can be traced directly to the invention of the wheel in Sumeria and the discovery of oil and the various usages of oil. That's what has underpinned and continues to propel our contemporary socioeconomic infrastructure. The data protection now recognizes we're a new era whereby data is the new oil. And interconnectedness becomes our new wheel, so that your ability to link across geographical or jurisdictional bases becomes a competitive advantage. And these competitive advantages realize the socioeconomic gains depending on how much data you have. So a Data Protection Act takes it and says, for you to be a person, what we have in the Constitution as the right to privacy, how can we actualize it within a society whereby, number one, there might be legitimate processing of your data. Number two, you might actually wish not your data to be processed at all. So the right to be forgotten. Number three, you have minor children who may require to access hospital, to access schools, to access all these services. How do we ensure they have their data, but that data is not exploited? Even when you are giving this data, the Data Protection Act goes and ask yourself a simple question. How do we ensure that you give your data knowing what it will be used for and thereafter being in a position to refuse or to, at a certain point, withdraw your permission for your data to be used? So that you get the right to informed consent. So there's no way in the Constitution you'll go and find the right to informed consent. But in the Data Protection Act, you'll find it. There's no way in the Constitution you'll go and find the right to be forgotten, but in the Data Protection Act, you'll go and find it. You never, where in that Constitution, you will find the actualization of the right to privacy within a digital mechanism, but the Data Protection Act does it. How does that help us? Because by Article 19, we're recognizing the ability to develop new rights, new responsibilities, new obligations, and new entitlement, it means that we are what you call adaptable. We are flexible. We don't need to go and amend the Constitution every new time we find a new technology. It's just to find the new technology, how does it influence pre-existing and predefined rights. And any rights we develop within that statutory basis will be able to be traced directly to the Constitution. Now, this I will call liberalist view of the Constitution has its own problems. I know some people may perceive when you are sitting on the other side of the government, but the basic guideline for interaction between the government and the public is to prevent the abuse of the law by the government. And as such, you should have very strict requirement and limited criterion for the government to limit access to these rights. As a practitioner, a few years in, having, I would say over 60% to 70% of my constitutional work has been done depending on the day and time, always defending the government. If it's a government ministry or it's an executive action. And you then start appreciating the nuances. But previously, pre-2010, we used to have the question of, have you met the test in Anarita Karemi Njero for you to have locus standi. The constitution that now says anyone and everyone can approach the court has created a new wave of guerrilla warfare, whereby now we have opposition by litigation, legal warfare as we call it, or op legs as we call it in the other side of the government. You'll also find there's another question that has arisen, legal mercenaries, and there is what you call blatant abuse of the courts. In but I've seen circumstances where someone who disagrees with a government policy, especially when you are about to resign, you find that person will seek someone to become a petitioner in a suit, and they will get an order preventing them from leaving office even after they have attained the retirement age, and will spend the next 2-3 years in court. So for the government, out of frustration, it's forced to enter into a compromise with that person, but ordinarily would not. And I have at least 2, 3, 4 cases I've seen in my short practice where an head of a parastatal or a government entity holds everybody as a hostage by instigating a suit. So the question of locus standi has become slowly is evolving to be something of concern. We have had at least 2 matters in the Supreme Court, whereby the first question that has been fought, very, very, I would say, guerrilla warfare kind of fights, leaving no prisoners, is a question of standing. And when the Supreme Court continues to uphold, but anybody whom it be affected as standing, I can conceptually conceive a day the Supreme Court will actually redefine this question of standing, because it has become a concern on how it's open to use and misuse or abuse by other stakeholders. Now, the second issue, which always is frustrating, is that qualifier to socioeconomic rights, but will now be accessible to the extent of our available resources. Now, what that has done is, unfortunately, it has created the biggest excuse in government. Anytime the government doesn't want to do something, it will always tell you it's a question of resources. DMR, as we throw it around, domestic resource mobilization capacity. So that if tomorrow you try to force the government to offer primary health care for free across the country, you'll be told, no, the amount of money we have to spend on healthcare is X, is Y, is X. Then when you sit back and read the national, not budget, because no longer, the Finance Act is no longer the budget, it's the Appropriations Act and the Division of Revenue Act, DORA, as we call it. When you look at DORA and the Appropriations Act, you find a very peculiar habit, but recurrent expenditure, paying for salaries, paying for loans, and paying for the lifestyles of our elected leaders is taking up increasingly more and more of our resources, while the money being devoted to basic needs is becoming either shrinking or stagnated. Then you'll ask yourself, will you ever have enough domestic resources to be able to realize these socioeconomic rights? There is a case, unfortunately, it involves the late President Moi, but there is a case from the Supreme Court on this question of domestic resource mobilization, and to what extent can the state continue still claiming it doesn't have enough resources for it to meet its constitutional obligation. So on this one, the state, I don't expect there is a day the government will say it has enough money, so now it can support and facilitate, because its job is to facilitate everybody's attainment or enjoyment of basic rights. I don't think that day will come. And since that day will not come, I don't think we'll ever be able to have the broadest, largest extent possible of enjoyment of socioeconomic rights, because that financial burden will always remain outstanding. That's my comments, Jesse.
I think I'd also like to hear from Mr. Kegoro on the same, in terms of some of the limitations that are currently there that actually either hinder the realization of these rights as have been provided for, or actually make it difficult, so to say, for the common Wananchi to actually feel that these rights are actually working for them and are there for their benefit.
Let me just talk about the space of digital rights and how that has changed the relationship between citizens and and the government. the traditional form or form in which people interacted with government, there's still quite a bit of that. Is you go to a physical office somewhere and you make a queue as a mwananchi, you fill a form, and there's a person, they'll stamp it, and you'll go to the next queue. That was the relationship, and it had many problems in it because the person who is supposed to receive and stamp the form, he may not be there, or may demand a bribe and so on and so forth. It had many frustrations, but it also was a way through which that interaction between citizens who are human beings and a living human being behind a desk who is a government official, that interaction was the discourse and the engagement between citizens and their government. In the digital age, lots of the transactions and lots of the interaction between government and citizens is digital in nature. If you want a government service, you're often being told, go to some portal go to eCitizen and start your process there. So you'll go to eCitizen. If you want an ID, you start there. If you want a driving license, you start there. If you want there's a relationship with KRA, you start there, that kind of thing. So that changes the nature of interaction between citizens and the government. The government becomes, the citizens become not citizens and right holders, but they are referred to and regarded as customers. There's a difference between a customer and a citizen. A citizen has certain power. When you're a customer to the government, the government is not different from Safaricom or another mobile service provider. It has it has customers. Those are commercial relationships that are based on subscribing and so on and so forth. So the digital age and the digital interaction changes the nature of the relationship between citizens who are then referred to and treated as customers rather than as citizens. Citizens have rights. They are stakeholders. You can't do anything about it. They come with power. Customers don't necessarily have power. It implies that they can walk away because they can get they can get an alternative service. But the nature of the relationship is, if you want a government service, there's only one government that can give you that service. So that is one challenge and limitation that comes with the digital age that we are living in. The second one is all the barriers to access, and there are very many. One of the barriers to access is based just on age, the nature of younger people sort of have a greater affinity and uptake for technology. So you'll find that despite there are many other limitations, younger people, Gen Zs and others, have a way of interacting with the state because they have a better way of relating with technologies. So older members of society who need to interact with government will have greater hindrance and greater barriers of access to situations where they can do interactions. There are also things to do with poverty and the spread of other services that then ride on the technologies that are the basis of the relationship. So, for example, access to electricity, because you're not going to have meaningful digital transactions if you don't have electric power. Fortunately, there's significant access now than was the case when I was born and growing up, but still there isn't universal access. And even if there was universal access in terms of it is available to you, there are questions of cost, and those questions of cost are not discussed anywhere, but they continue and remain significant barriers in and of themselves. So those are important limitations in and of themselves. There are things to do with what came with the Huduma number, which represents trust issues, and I think there and that thing called trust, which is um, an understated but necessary part of the relationship between the citizen and the government, is also significantly displaced in the digital era. One of the questions government was not able to answer in relation to Huduma number is, why would citizens trust their government that the things they wanted to do with the Huduma number are the ones that, and only those that they would end up doing? There was a high level of mistrust, and unfortunately, that burden of trust was not discharged, because what the government did, it ramroded a very costly program that was ill explained to the citizens, and implemented it, notwithstanding court injunction against that. And then the next thing is, people were being asked to surrender their information to the state, and then we've not heard about it after that. Uh, it went silent. That is not the way to build trust. And there are variants of that, where government goes out of its way to collect the information of citizens, the data from citizens, which is something which is an enterprise that is carried out in a context of very high, very richly deserved low levels of trust. So I would say that also because government finds it easier, technologies to make it easier for government to get away with that, with the burden of failing to explain itself. If you go to villages, you're doing maybe an inoculation process or whatever process, and you need to explain yourself, then you have to talk to human beings and have an interaction where the case is made to people to the satisfaction of everybody. When you have these new digital types of relationships, it's very easy for the government to behave like it has done many times, that from tomorrow onwards, if you don't have this and this and this, you won't have access to this and this and this. And that is very easy to implement because digital possibilities make that very easily possible. They make it possible to shut out people, to exclude people, to include others without the need to make the case and without the need to build trust with the population. And this is the point where I start moving. So I'll just switch devices, and I hope it will remain smooth. Thank you very much.
Thank you, Mr. Kegoro. Thank you so much. Just to flag to those in attendance, in case you have any questions in the course of this session, specifically directed to Mr. Kegoro, you can channel them through the chat, and we'll be sure to share them with him. But yes, thanks so much, Mr. Kegoro, for the time that you've had with us. I'm sure you'll still be logged in, and we'll find a way to accommodate you even as you're in transit. But thank you so much. I think I'll just pick up from where Mr. Kegoro has left off, and I guess then directly be channeling this to Mr. Nkarichia. So Mr. Kegoro has brought up the question of, for instance, the Huduma number rollout, and how sometimes, the government would use such situations, for example, to limit access to certain amenities, certain facilities. And probably my question to you, Mr. Nkarichia, as we're slowly evolving into a more or less digital society, probably foresee a situation whereby the use of biometric data hinged on, the public having trust in the government could be used as grounds to enable, for instance, access to services and actually work for the public good.
Let me split your question into two. Do I see a future where the government turns to biometric unique identifiers to assist it in service delivery? Yes. That happens even today. Well, it happens in a manner that you may not be aware of, it happens. The easiest example I'll give you is today, if you decide to pass out of Kenya to another country at the border point, they'll ask you for your passport. Currently, the government does not recognize the old generation passport. The only passports we currently recognize are the new generation. And the main features of the new generation is they contained by your biometric data. That's the easiest way, but I can show you that biometric data is already working. The second way you may not have actually realized because you are in school, but if you went out a SHA, SHIF and related health insurance approaches by the government, most of them rely on you giving your fingerprint, and when you go try and access healthcare, they will ask for your fingerprint. Previously, when I was a few years ago, let's say 2008, 2012, when I accessed medical services, then it was enough for you to say your parents' ID number or your ID number, and they will confirm where you are registered for NHIF or relevant health services insurance program. Today, it doesn't matter. I've seen instances where even colleagues at the office, and ours is a private insurance policy, you go, you are sick, you present your ID, you are told no, they need to take your fingerprint, they need to take your scan of your face. So we are already there, it's that we are yet to roll it out. You may also not realize this, but whenever you take your national identity card, the government takes biodata. Since I took my ID more than 10 years ago, the government even then was doing that. The only problem was it was not digitized and there was no law to underpin it. So that everybody in the class or in the session who has ever had the opportunity to get your ID, they told you put your finger here, put your finger here, put your finger here. Look at that point, let us take a photo. That is biometric data by and of itself. It may have been taking your thumbs and putting them on a sheet of paper. But that's biometric data, and it's possible and capable of being digitized. So we are there, but we cannot run away from. The question that arises is the trust deficit that you had Mr. Kegoro mention, and it's a legitimate concern. So legitimate, I will tell you, go and look at today's newspaper. The Permanent Secretary for the National Treasury has been summoned by Parliament to explain why e-citizen money disappears. But if today you pay money through e-citizen for whatever service, that money will appears to not get to the National Treasury. So you start asking yourself a question that I've asked in another platform, and I'll repeat it here. Do you really know who owns these digital platforms through which government provides services? The short answer is some people know who owns them, and those who know who owns them have repeatedly held it's not owned by the government. Again, today's newspaper, you will find that the teams for NTSA teams, the Transport Integrated Management System, where if you get your logbook, you get your number plate. I think it's on page 4 of the nation. Also, NTSA cannot tell you who owns that network. They agree they don't own the system, they agree they use the system, and they are not willing to disclose who owns it. So the contemporary world has led to what I will call privatization of services and privatization of rights. Well, Mr. Kegoro says citizens are not customers when you are accessing these basic rights and related obligations. I will be sorry to disappoint everybody and say we have gotten there. Because right now, if you have a problem that you need resolved by the government, it will be sent to a citizen. If you access a citizen, the provider is a private person. If you have a problem accessing a citizen, you raise a ticket to a private company for it to do or try to resolve your issue. If tomorrow you try to get your number plate, you have an issue, you raise the problem with a private company first. The actual NTSA employees were government employees. The actual business registration services, national records management services, all those public servants are only able to interact with through a platform but is privatized by its very nature. Even our own iTax. Look at the bottom. Today, I'll challenge you, access the iTax for KRA. At the very bottom, it's written powered by Tata, an Indian company. So the greatest challenge that will always exist is that until governments develop its own intellectual property to be able to own and operate this system, the government will always be held hostage by private stakeholders who provide the intellectual property that is the bridge between the government and the employees. There is a podcast we did somewhere at the office, and a question arises: who actually owns Arvisasa? Because currently the government is pushing everybody to Arvisasa. But you keep asking them, who owns Arvisasa? Who has the power to delete my title tomorrow morning if I make them unhappy? An answer has not been forthcoming to date. So I'll say the entire spectrum of rights that we expect from the state, basic and fundamental rights, will slowly transition to digital platforms. And as citizens, we have to start questioning what is the actual role and scope of government when you are interacting with it in digital platforms, specifically because whoever owns the system can be able to dictate access availability. And access is not even a question. Is it accessible from, is it available on from 8 a.m. to 8 p.m. or all day? Is it cost accessible? Are they going to charge a service fee of 100,000 when the actual fee needed by the government is 50 shillings? Remember the entire debacle of renewing your ID cards if you lost it. So essentially, the primary question that comes is ownership, but platform will dictate access to that platform and will inform availability of that platform. And that speaks for all these other rights you want. Even if tomorrow you want your right to be forgotten, let's say for an example, someone takes photos that you find really objectionable and you try to process that dispute, your first point of call is the Office of Data Protection Commissioner, where you will lodge your complaint via email. But have you asked yourself who operates and manages the government servers for their emails? Who can delete that complaint of yours from the system? Tomorrow, the ODPC will demand to have a hearing virtually. Have you sat down and asked yourself who manages that virtual platform? They will deliver their determination through email. Then you will have to file an appeal at the High Court e-filing system. Have we asked ourselves who owns that electronic filing system for the judiciary? Then the judge will have their virtual calls on Microsoft Teams. All of us can tell who owns Microsoft Teams. Deliver their ruling. If you want to apply to the Court of Appeal, you go to Go Meetings. It's Go Meetings, another software used by the Court of Appeal. Who owns it? So the question of ownership will inform access and availability. And in my opinion, which could be very wrong, the extent people are able to enjoy these rights as society becomes more and more digital, but we don't question the underpinning mechanism amongst the public and with the government on which we get to enjoy or otherwise maintain our rights. That's my take.
Thank you for that. I think it probably easier to address one last question. So one of the things you've both highlighted with Mr. Kegoro is that there's a trust deficit, and the trust deficit is there more or less for a reason. So there's limited room for us to ensure accountability or to actually track down who's responsible for what's happening on these various platforms. So probably my last question for you would be in terms of pushing for accountability, is there room within the civil space, within the legal space, to actually try and hold, on one hand, the government accountable, and probably all these private actors who are involved in handling, for instance, user data, accountable, so that at the end of the day, the rights that stem from whether it be the Constitution or the Data Protection Act are not infringed? Mr. Nkarichia.
Is there a way? Yes, there is a way. I think Mr. Kegoro mentioned the Uduma number case, and it's a testament on the role and maybe what you call the space occupied by non-governmental organizations when you have questions pertaining to how the state interacts with the citizen. The easiest and what would ordinarily build trust in government is having effective public participation. But tomorrow the government can come and tell you, we have noted there is fraud in land matters. We want to look for solutions to fraud. And then you get a government and a public sector-led engagement whereby you develop the solutions, then formulate the appropriate laws, and then implement them. That is something that everybody will have wholesale, what you call buy-in. You accept because you are part of the decision making. So if the government ever had a challenge and really wanted to have a solution that will be acceptable and workable, the easiest thing is what you have always said. Let's have effective public participation. And you'll note I'm not saying public participation, I'm calling it effective because we all have seen the forms of public participation in this country. Some of them are window dressing, some of them are salad on a tash, but it is a country that we find ourselves in. The second issue that we would speak to there is that now as a citizen, if the government decides to disregard you and promulgates a public policy that it decides it wants to implement, unfortunately, a matter of public policy is not justiciable. It's not something you can take to court and challenge. You'll always be told by the courts, but a public policy is not something that has risen to the extent of a law for you to challenge it. So you'll have to wait for the legal manifestation of that policy and then seek out to challenge it through the courts. Now, if the courts become the only guardian of these rights, it means our ability to enjoy these rights and our ability to keep the government to account is informed by and large by how strong a judiciary we have, how resilient is the judicial system to ensure it does not become influenced or in any way intimidated by the executive. Now, that's the easiest route for everybody to take because of the cost issue, availability, and accessibility. You to sue the government, it's very easy. And there has been substantive gains made over the last few years, despite from the smallest problem to the largest problem. The largest problem I think we had was the Building Bridges Initiative, the attempt at amending the Constitution. If that could fail, if the Finance Act for 2024 could face so much challenges until it had to be withdrawn, you are able to clearly ascertain that the judicial route offers the easiest route that you can actually quantify the results and the level of success that has been gained. There's another route that very few people want, but it's one of the most sustainable routes. It's the civil engagement space. But all of you, I would say the challenge is go get a national identity card, go get a voter's card. If you punish consistently and long enough, you are elected representative, you will find that eventually they will start working for you. And there can be nothing more powerful than a functional parliament. I always pride myself on the fact that I come from a county in which we have never re-elected a governor. We have had 3 governor elections since the new constitution came into place. There is not a single governor who has tasted office was more than a term. I also come from a county that prides itself in having a constituency that I think someone has served for the last 3 terms. But before that person served those 3 terms, my constituency had had a different MP since 1963. Because every single time you get into office and you don't serve or meet the promise you gave to the locals, they are not the most educated, but also they are not ignorant. They can tell you are not working, and at the election, they'll teach you a lesson, irrespective of how much you try to bribe or get your way through. So then it becomes, once everybody is aware that you will vote them out if they misbehave, you will vote them out if they don't defend your interest, you will vote them out if they become corrupt, then everybody strives to work as hard as possible to get the essence of the public to allow for their re-election. Because politicians live and die on the basis of their last electoral win. Which means if we wanted sustainable and actually long-term change and long-term defense and long-term progress on all the rights that we strive to achieve, maybe civic engagement. And civic yes means being politically aware, being politically active, and ensuring you strive to realize your political interest. Then you find it becomes very easy. But while the government may wish to go rogue, the role of parliament will come into effect to ensure that rogue government doesn't materialize. If the government tries to go rogue, parliament will deny them money through the Appropriations and Division of Revenue Act. If government tries to go rogue, parliament will decline to enact the law that the government needs to support its rogueness. So the sense becomes then, the easiest way to hold the government to account. It's also the easiest way to advance human rights. And it's the cheapest because there is no fee on you being a registered voter, you having a voter's card, and you are electing out anyone you disagree with their policies. And it's regular, happens every 5 years. That's my take, Jesse.
Thank you so much, Mr. Nkarichia, for that. I remember you had flagged certain time constraints, and I noticed that it's already 3 or 6 p.m. So I'd probably at this point open the floor to any questions that may be there. So for those in attendance, kindly, I believe there's a Q&A option on your end. Feel free to post the questions that you have there, and then we shall be addressing them to Mr. Kegoro and Mr. Nkarichia, even as we we wind up the session. So I think I'll address, yeah, there's one question I have on this end, which I'll pose to both Mr. Kegoro and Mr. Nkaricha. And the question is, what is the place of online expression in Kenya's constitutional paradigm? In particular, is Article 33 and 34 adequately enjoyed by its main stakeholder, the people? So asking this, keeping in mind the culture of stifling expression through social media platforms and content creation. So probably, Mr. Kegoro, if you're still with us,
Yeah, can I speak to that? It's an extremely important question, and I'll answer it this way. In the early years, the greatest, protest. I think I'll answer it by looking at how, for example, expression and within the larger realm of expression, political expression, including political protest, how it has manifested itself through generations. The earliest forms of mass communication was radio, and then the print. And in our particular case, radio in particular has been and remains a very, very significant form of expression. When I came of age and became politically conscious, the print, which was newspapers, were playing an extremely important role in expression. Radio as a way of expression was important, but the fact that in the early years, in the 70s and until 80s, when airwaves start being liberalized, the fact that most radio stations were controlled by the state meant that there was very limited use of radio as a form of expression, also as a form of protest. It meant that the only viable way of protest or alternative political expression tended to be the print media. And because newspapers also ultimately are vulnerable to political pressure, the forms in which that expression would take place in Kenya's contemporary history has been around underground publications like Mwakenya that form part of the history of this country. The people who engaged in those publications in that form of protest, if you look at the current, the generations of political actors, like sedition and related charges. people like the late Georgia Nyona, Jeruka Thangu, Professor Yugi, and punished as that are doing that form of expression largely digitally. So the new seditionists, if you call them that, are all the young people who are waging forms of expression that the state doesn't like and that the state often punishes, and they are often very young, and they are the sort of the age of the people who are the audience in this conversation, who are maybe students, and they will be doing caricaturing, they will be doing all forms of the things that have been done in digitally. My submission is that if the people that we talk about fondly, like Imanyara and Georgia Nyona, if they were national heroes and if they were worthy of protection and the celebration as we do of them nowadays, then the young digital warriors who are successors of in that tradition, they are worthy of protection, they are worthy of celebration, and they are definitely not deserving of the kind of reprisals that go against them, as we've seen in the recent past. All this to make the point that digital forms of political protest and political expression do not amount when there's backlash against those forms of expression. When there's political backlash, it does not receive nearly the same level to the old seditionists who, whenever they were under attack by the state, it raised a lot of political and public concern. But the fact that digital forms are kind of removed from the mainstream of where public opinion is, it leaves the current digital champions bereft of the kind of political protection that was afforded to the former seditionists, if I may call them that. That is my long answer to your question.
Yeah, thank you for that, Mr. Kegoro. I think there's another question here that was directed to Mr. Nkarichia, but Tracy Jerop, if you could kindly type out your question in full. I don't think you've captured it completely. But in the meantime, there's another question. How can I advocate against mass surveillance in my country? Probably target this to Mr. Nkarichia.
The short answer is you can't. You can try, but you can't. And I'm saying this from a genuine point of view. But the moment you buy a phone, a digital phone, you have put yourself into a mass surveillance system of even the small Republic of Kenya that we have. There's a decision by the Court of Appeal last week, Thursday, Katiba Institute versus Communications Authority, and I think three others, whereby you find the question of, and KRA is a party to that. Sometimes 2 years ago, KRA started modernizing its system, and it was requiring Communication Authority to ensure any phone bought in Kenya comes with its IMEI number, and that number is disclosed to KRA. So that KRA will have your name, your ID number, your mobile phone number, and your IMEI. Now, if you are the kind of person who earns a salary like me, and your employer deducts your pay from the word go, there's no problem. Or so you would assume. The challenge you find is that the moment KRA gets your IMEI and your phone number, they'll be able to track each and every transaction you ever do. So even when my girlfriend or wife decides to send me 50 bob for dinner and I spend it, to KRA that is income. So for me, who was saying this is just I'm taxed at payee, then at the end of the year, KRA will demand additional taxes saying that I received income from my wife or girlfriend and I ought to pay taxes on that income. It will become a very, very uncomfortable position. For those who believe that a mobile network operator is the one behind the kidnappings, you can tell how easy it will be now for whichever government agency to ask from KRA the IMEI of every number, the phone number, the name of the person. And then by using your records of what you have been purchasing, we find where you live, where you like to frequent, and the resultant effect. So the day you buy a digital phone is when the mass surveillance begin. That's my genuine concern. Because today to register a SIM card, we require a copy of your ID and we require a photo of your face, which means that is where the surveillance comes from. Now, there are solutions to it, and the easiest solutions is to always make sure that any reasonable regulation being enacted by the government has what we call a public policy means and justification. So if the government is going to say you must register your SIM card, we must ask, is the state security excuse enough justification for everybody to be requested to register their SIM card? If the answer is yes, then how much information does the government require for the government to arrive at the conclusion that we have all the details we need to separate individual owners of these funds? Now, another way you can consider yourself and advocating against mass surveillance is opt out. Opt out of as many things as possible. Whenever you get a message to opt in, whether it's 15% off KVFC, whether it's Uber 10% off, whether it's attending a political rally where the cameras are flowing, opt out of as many things as you don't need the essentials in your life. Now, can we really? No. When you go for your healthcare tomorrow or for SHA, they will have all your data on a file. When you try to run away from SHA, you try to buy a car, NTSA will have all your data on file. When you move apartments from one apartment to the other, Kenya Power will have your data the day you move because it's somewhere in a record. And the government will have access to all this information. So the easiest way to advocate against mass surveillance is to try and make sure you actively engage in the political process, whether formulation of law, electing of representative, or even interactions with your local authority, so that any regulation made that requires information from the citizen must be justified, and it must be the least invasive, the least disproportionate request of information capable of being sought from you. The bare minimum is what should be the maximum. Otherwise, the more information you give to the government, the more mechanisms they have to continue with mass surveillance. That will be my response.
Okay, I think I'll still pose one more question to you, Mr. Nkarichia. Just taking you back to the question around Article 33 and 34, which had been raised. And I'm directly raising this, or rather, yeah, addressing this to you since I believe it's something you litigated on up to the Supreme Court. And it's a question of raising the first question by Ruth. Where do we strike the balance between the state regulation and self-restraint by media houses in that the guarantee or the enjoyment of one right, for instance, the freedom of the media, does not infringe on the right to privacy, does not infringe on other, yeah, for instance, the right to privacy. I'll just use that directly because I guess it's something that came up, I think, in CMM and six others versus Standard Group and others. So you could probably touch on that slightly.
I'm a firm believer that the government has no business in freedom of expression, whether it's media or the individual, because of the simplest thing. Why would you be concerned about people reporting something? If it's a lie, the law of libel and defamation is sufficient and adequate deterrence. You should ask anyone who has ever worked on a newspaper or anyone who has worked on a TV. They employ lawyers specifically to advise them on each and every content. Every newspaper you read on any day has been read through by at least three editors, one managing editor, and the legal officers had a look at some of the headlines. Because at the end of the day, if you sued, let's say, the Standard Monday to Friday, and everybody got an award of 10 million for a lie, by Friday it's 50 million, I can assure you that is more than the profit they will ever make for that month. So there is already a financial incentive for newspapers radios, TVs, not in any manner to commit libel or defamation. So why would the state be concerned? There can be no justification, in my opinion. I suspect you are about to tell me what we told the Supreme Court, but that one, I was acting for a client and we had a client's interest to protect at that stage. Now, on the other side, and it's a side that the Republic always comes through, is that we live in a society. Our society is a compromise, and I say yes. If you look at the Kenya Information Communications Act, there's the Multimedia Appeals Tribunal, and there is a Media Appeals Council. If a media has determined its fit to have self-regulation, the only role the government needs to do is ensure that self-regulation is effective. Ensure that Multimedia Appeals Tribunal has enough staff. They have the resources and capacity required for them to resolve the disputes that appear before them. Otherwise, the more the government tries to intervene, the more it creates a circumstance. Look at Poland, whereby you begin with a very dependent media, but by the time the Law and Justice Party, and a misnomer of a name, by the time the Law and Justice Party was in power for 10 years, the entire media had become a subset of government propaganda. So the question is, any instance where the government has to intervene, then we must say that the law of tort has failed. Defamation and libel are no longer sufficient incentives. And personally, I've always held it to be the personal rights of a person's presence, no matter how offensive, must be protected. Because you are not entitled, and nobody will ever be entitled to an environment free of what do you call it, disparaging remark, free of a remark that you find disagreeable. The only thing we should do is we should not permit insult. We should not permit a lie. But just having a negative or a critical view cannot be criminalized and cannot be limited. So even when the state says it's important but we don't have live transmission of TVs, and in the interest of full disclosure, our law firm is acting for the communication authority on that matter. I'm not in it. But even when the government argues that you should not have live transmission for TVs, the argument that a member of public will have is very simple. Why not? If when you had 90 in the United States, there was airing of that entire episode. What is so wrong with airing it in Kenya? It's because the government knows the police force are engaging or potentially will engage in illegal, criminal, or prohibited activity. And the moment you allow for there to be an opportunity where there is no transparency, that's how slowly the erosion of basic rights begins. That's my take. Yes.
Thank you so much for that. I don't think I can see any other questions. The one that was raised by Tracy, but I don't think Tracy Gerard, but she hadn't typed out the whole question, so I don't think we could probably address that in this session. Okay. Since you're asking about mass surveillance as well, I think with that, given that both our panelists had flagged that they'd have time constraints, which would limit their participation up until 4 p.m. I think at this point, we could bring the session to a close. And before we do, I'll probably ask if Mr. Kegoro has any parting remarks. Then after Mr. Kegoro gives his parting remarks, we can have um, Mr. Nkarichia give his closing remarks, then bring the session to a close. So, Mr. Kegoro, if you're still with us, any parting shots in relation to what we've discussed today? Yeah, he seems to be indisposed. I think I'll pass it on to Mr. Nkarichia. Any closing remarks from your end based on what we've discussed today?
Thanks, Jesse. And I will tender my apologies. Today's session, I'm told, has been slightly shorter than normal because of a bit of other commitments. You will note it's in the middle of the week, and law firms tend to be sometimes slightly hectic, sometimes less hectic. So when I accepted this offer, I had some time constraints. They have kept becoming slightly challenging more and more. So accept my apologies for that. But on another level, I'll say the question of digital rights is a contemporary problem that you will only get to appreciate it if you read more about it, interact with the space, and try and contribute. Something I always keep in mind is that every new area of law means there's no expert, which means you as a new learner in the field has an opportunity to become the expert. Nobody will be consistently telling you, oh no, read this article by whatever 1901. This point has already been argued by whatever 1968. If it's a new area of law, that's the area you can actively and have actual personal contribution. I knew Mr. Kegoro very many years ago when I was in college because he was one of the leading people for the quest for the 2010 Constitution. And when I began college, the 2010 Constitution was very new. And we kept seeking him and his colleagues' opinion on how we were to treat this Constitution. So for you now, I would say it's still the same. The digital rights that you see has canvassing today and the questions we turn on the fourth generation rights are questions that are ripe for you to actually do your research. There is no set or defined answer. Explore it and let have actual contribution. You may think you are too young or too inexperienced, but I tell you, your fresh take might be the only take on a specific issue. I can count on one hand the number of articles I've done I've read on the right to be forgotten in Kenya. Very few, which means if you have a deep interest, try it, you may get it. If you decide to work for whichever side you work for, no side is innocent in the fight for fourth generation rights. I know some people believe this is the worst government possible. Some people believe the civil society is the worst monster possible. I say none is right, none is wrong. Try and appreciate that every circumstance has a nuance. And once you realize that every opinion is based on an experience, try and understand how that experience comes to. Then you will be able to get an informed view on to what extent do we need these rights and to what extent should we protect these rights. That's all, Jesse.
Yeah, thank you so much, Mr. Nkarichia. Uh, thank you for your time. Thank you to Mr. Kegoro as well. And thank you to everyone who was in attendance, who joined us for this final session of the Katiba at 15 webinar series. So today's conversation has looked at a few areas, though we haven't managed to exhaust the time that we had. We've at least been able to appreciate the beauty that is Article 19 of the Constitution, which gives room for the recognition of rights that may not be explicitly addressed in the Constitution. And It's been an honor to have Mr. Kegoro and Mr. Nkarichia here with us today. I extend my sincere thanks to them for the time that they've set aside and for their reflections and contributions. And I think at this point, pass it. I'll pass the baton over to Mr. Cedric Kadima, who will give us a vote of thanks, and then we'll have Ms. Ruth Jabet close with a word of prayer. Mr. Kadima, if you may.
Yes, thank you very much, Jesse, for moderating the session. I would say this has been one of the most impactful 1.5 hours we've had on quote unquote the fourth generation of rights, or rather what we term as the evolving rights. Indeed, one of my major takeaways today is that our major contact with government is now digital. And I think we have demystified the whole concept that governance is far from the citizen. I think back in the days, I used to hear, for example, my dad picking a car and traveling all the way to Kakamega just to access provincial administration. Or I would travel all the way up to Mumias for me to get my identification card. But these days, you can just pick your phone, log in, and you can access whichever service you want within the government. So at least these digital rights have brought the governments closer. And we really appreciate the passion that gone through around that subject. I want to personally thank Mr. Nkarichia expose he has done it today. Of course, from living with some state secrets that he has revealed here, including that the government does not know who owns eCitizen or who owns the teams by NTSA, and these are very vital organs to the operation of services within the government. We should really question of who actually holds our data. And I think this serves as a beginner platform for us to put more questions and to put more accountability on these evolving rights. I would also like to thank Mr. Kegoro, though he has left for another engagement just towards the end, but I would really like to appreciate him for sparing time to be here with us. Again, at the Avid Readers Forum, we are most grateful for sparing time to take us through this subject surrounding Katiba at 15. And maybe just to mention something that we could have mentioned at the beginning, this is our last series on the discussion of the rights under the Constitution of Kenya 2010. Over the last 1.5 months, we have done the first, second, and third generation of rights, and this is now our last one today. And I'm glad that it has been very engaging and it has been very impactful. So I would like to thank the panelists. I would like to thank the moderators for that wonderful job. I would also want to thank Ruth, Stanley, Nyamu, who are on the platform. They have been really helping us with the logistical part of this session, including just generating the links, a few communications here and there. I would like to thank them. And in my father's house, later in life, you should have a space. By my father, I mean, of course, later when we go to heaven. Thank you all for attending. Thank you all for sitting through the session. I don't know if we have tea, but you can always take tea whichever place you are in remembrance of this session. Thank you so much. Na muwe na a very good evening. Asante.
Okay, thank you so much, Jesse, for the opportunity to pray. I'd like to echo my co-coordinator's remarks on Thanksgiving to everybody who has been active in participating for the series that we have had, and Jesse also for your wonderful moderation. Just to say that you're also an emerging digital rights expert, and we are very excited for you with regards to that. And we know that you're a student who, currently doing your KSL, but it's really great that you're able to do this and do it really well. And also to the rapporteurs, George Skem, Young Green, and the rest who help us every day to take reports of these sessions. We also thank you so much for it. And without talking too much, I would like us to pray. Oh Lord, thank you for this day. Thank you for the opportunity to have 4 different webinars where we've discussed the promise of Katiba at 15 as a precursor to the Katiba at 15 conference in Kabarak Law School. Thank you for all the panelists who have participated, and even for today's session that has indeed been fruitful and impactful. May you help us that you might continue forward, not only as students, but also as citizens and also as civic members of our community to continue engaging with the Constitution and continue pushing for the realization of these rights. And even as we do so, we pray that you might strengthen us so that we might continue having the courage to stand for what is right. And at the end of the day, all glory and honor will go back to you. For the sake of trusting, believing. Amen. Thank you, everybody, and have a lovely evening. Goodbye.